Welcome, everybody. We've got both an expert panel and an expert audience. I'll come on to that in a moment. This is a seminar from Garden Court Chambers. We're a multidisciplinary chambers, which means that we're able to attract some expert speakers, both from within chambers and outside, in a range of multidisciplinary topics. And we're going to hear about issues from the criminal law, issues from how civil law is used, and so on, and in a very interesting and important evening. My name's Stephen Simblett. I'm a barrister at Garden Court Chambers. I have been, in fact, looking down the list of people we've got here. I once spent an evening out in Ledbury with Mike Schwartz when we were in criminal proceedings involving the Castle Morton rave in the early 90s. And then I've spent this afternoon in court with Stephanie Harrison defending injunction. So in a sense, the timeline that we've got here goes from the early 90s to literally half an hour ago. And unfortunately, the themes that we're dealing with in this seminar are the 30 years or so of oppressive attacks on protesters and protest rights, both through trying to criminalize protest and protesters, and also, as we'll hear in Stephanie's talk, and also some of what Paul is going to touch on, how the private power of corporations is used in civil injunctions, and the extent to which the state's resources are co-opted by powerful private interests to do down and control the people who are protesting and fighting battles that need, unfortunately, continually to be refought. Now, I should say this is being recorded and is also being broadcast over various multimedia channels and so on. So if you're reticent about disclosing who you are or whatever, be careful if you're contributing on the chat or the question and answers and so on. But what we do have here is not only a wide-ranging multidisciplinary panel, but as I said earlier, a multidisciplinary audience. We've got solicitors, barristers, academics, students, people from a range of campaigning organizations and campaigning groups. A lot of people have signed up for this, and we're looking forward to what I hope will be a very interesting and rewarding evening. I'm not going to spend long on the preliminaries, but just safe to say that at the end after we've heard from our speakers, there will be a Q&A, and on Zoom there is a Q&A function. If you've got any questions, if you can put them in that, then as the evening goes on, we'll try and select some of the questions and see what we can most usefully use our time to deal with. So I think I'll now move to introduce our speakers. We're going to hear first from Mike Schwartz. He's a solicitor and partner at Hodge, Jones and Allen Solicitors. He's been involved in protest work for many, many years, going back to the early 90s. He's been involved in many of the important criminal and other cases that have been brought in the protest field. And he's going to talk about some of the common themes in environmental protests and talk also about the undercover police inquiry and spy cops and the extent to which the police are used essentially to spy on protesters. Then we're going to hear from Rajiv Menon QC, who's Joint Head of Chambers at Garden Court Chambers. He's going to talk about his experience over the years defending various environmental and animal rights protesters in criminal proceedings, Newbury, M11, Hunt Sabs, Huntingdon Life Sciences, and in particular looking at how police tactics have changed and what defence advocates need to do in order to adapt when representing individuals involved in criminal proceedings. Then we're going to hear from Stephanie Harrison QC, also a joint head of Garden Court Chambers, and she's going to talk about the relationship between the criminal and civil law on suppressing protests and tactics, and in particular the methods used in the civil courts supported by police where essentially corporations and other bodies try to get injunctions so as to circumvent the rights to fair trials and so on of the of people involved in protests, and the important implications for Article 10 and Article 11 ECHR rights. Stephanie has been involved in defending injunctions. I mean, essentially the overlap between the topics that Rajiv is talking about and the civil injunctions that Stephanie is going to talk about is pretty. They run alongside each other. That the same people who are prosecuted in criminal courts for, say, hunt saboteuring or hunt protests and hunting and animal rights protests and so on are also the same people who end up on the wrong end of injunctions and so on. And Stephanie and I, even today, have walked out of a court hearing involving proceedings brought by UK Oil and Gas, trying to stop people protesting against essentially the development of oil rigs in the Sussex countryside. So it's not only a historical perspective, but one that's immediate and current. Then we're going to hear from Paul Powlesland. He's a barrister in Garden Court Chambers. He's going to speak about lawyers for Extinction Rebellion and how rebellious lawyers can influence the profession. And then we're going to hear from Audrey Mogan. She's a barrister in Garden Court Chambers. She's also going to be talking about the criminal proceedings arising out of the current environmental protests and so on, from a criminal lawyer's perspective, and including importantly things like how to manage how cases are dealt with and messed about with in some of the lower courts. So how to sort of address things like problems with listing or disclosure and important topics like that very often are overlooked by people who are focusing on what the substantive law is. And then finally, we're going to hear from Swan, who's a protester in a number of protest groups, a frontline activist currently involved in the HS2 protests, and herself, unfortunately, been a direct victim of aggressive and very aggressive police and private security tactics, including being dropped in the river off a slip line and so on. So essentially a voice from how the implications of this sort of coercive activity by the state actually impacts on real protesters, or the real problems for protesters, and what we can do to fight back against it. So a dynamic and interesting panel, and we can look forward to a very interesting evening. So with that, I'll put myself on mute, and Mike's going to speak.
Thanks very much. Hello, everyone. I've got 10 minutes to go through 30 years of history of environmental activism, which obviously is impossible, and people around this room have experienced many of the things already, so I don't need to tell you everything. So I'm just going to touch upon some themes, and fortunately others later on in the evening are going to pick up on them. There's also a 2-page note, which I think Garden Court are very kindly going to make available to viewers now and afterwards. And the idea of that obviously is to save a bit of time, so you've got the reference material for what I'm talking about. And the way I've approached this is these 10 or rather 9 minutes is to work out the characteristics of environmental protests over the years, and then consider how they've been tackled or addressed or challenged or attempted suppression by the authorities. It applies to lots of movements, and the environmental movement is very similar to many others, but it does have some notable characteristics, like it's often open, espouses the principle of non-violence, lots of mass protest, and often at the site of the pollution or environmental damage, like roads, coal-fired power stations, GM crops, incinerators, and so on, and obviously currently HS2 sites. And I sort of break down the types of activities into two. One is the more traditional symbolic protest, sit-down protests and things like that. And on the other hand, I suppose you can say there's direct action as well, where people are taking direct action to try to stop the harm that business and government and corporations are doing to the planet. And because direct action is most effective in the sense of stopping the pollution, it obviously attracts the most police action. But because another characteristic of environmental activism is that the activists are normally, well, invariably right, what often happens is their cases go to the Crown Court and they can rely on what are known as justification defenses if they're prosecuted. And I've listed a few of those, or the three key ones. As many people know, you can do what might otherwise amount to a crime if you're preventing a greater crime. That's Section 3 of the Criminal Law Act. Separately, if you're charged with criminal damage, if you acted with lawful excuse, then that's a defence to a charge of criminal damage. And third, if you act through necessity or duress, for example, if you're taking immediate action, which is reasonable and proportionate, to prevent and protect human health and life, then that similarly is a defence. And I've listed some of the authorities on that. It's a common law defence to put forward. And there's so many cases, it's impossible to spill them out, set them all out. But for me, these are some of the highlights. And although the first one I mentioned is not an environmental protest, it's about women who sought to disarm hawk jets that were due for use in East Timor, and as they saw it, commit genocide there. It's an important case, first because they were acquitted in front of a jury, and second, they reflect a long line of activism before the 1990s involving anti-weapons and anti-war campaigners. And on their shoulders, those movements, environmental activists have stood. And they were acquitted by a jury at Liverpool Crown Court, accused of criminal damage to causing millions of pounds worth of damage to hawk jets, arguing that they were preventing a crime, the genocide that the hawks would be put used to. And that inspired, as many people here know, a generation of other environmental activists. And one example is the Greenpeace action, where GM crops, which were about to flower, were decontaminated in a field in Norfolk. The activists were accused of criminal damage, value over £5,000. They put forward an argument that they were trying to protect other property and immediate needed protection, and they were found not guilty because the jury recognised that they were trying to prevent the GM crops from flowering and contaminating nearby conventional natural crops. They're also charged with theft, and the jury found them not guilty of theft because they were acting honestly to try to protect the environment. In terms of the law, the big case or the comments that are important and have resonated down the years are the words of Lord Hoffman in the case of Margaret Jones in the House of Lords. That was a campaign where people tried to prevent the Iraq war. Some tried to invade Fairford Air Base and other places. They were accused, for example, of criminal damage. And at paragraph 70 of that seminal case, Lord Hoffman tried to restrict the scope for justification defences. And paragraph 70 talks about the limits to self-help, and you can read it there. It's a reactionary, virtually knee-jerk reaction to activism and to citizens' action. But unfortunately, it's got a grip, and it's often referred to by judges who have followed it as a reason for preventing justification defences being put forward in trials. But they are still put forward, and they were. So in 2008, at Maidstone Crown Court, Greenpeace activists were acquitted of criminal damage when they climbed and painted a message on a coal-fired power station to try to stop the CO2 emissions from being emitted there. They were arguing they had lawful excuse and acting to prevent damage to human health and life, and they were acquitted. And most recently, in Cambridge Magistrates Court, XR activists, or at least one, was acquitted of criminal damage to Shire Hall there, arguing that she too was trying to prevent damage and death and destruction. And that case, I think, has gone to appeal very recently. We may see in the High Court what the higher courts say about these justification defences. And of course, most recently in the Stansted 15 case, obviously a case of deportations rather than environmental activism, the Court of Appeal looked at these defences again, didn't make a ruling on the particular point about whether necessity was open to activists trying to stop deportations of people who might face torture and death if their immigration status was not recognised. And the Court of Appeal made comments which suggest that the key question in court cases will be first whether these defences should be left to the jury, and if they are, then whether a jury can properly acquit. And that's a romp through some cases that struck me as significant. But equally significant, I think, are the responses by the authorities before it gets to these high courts. One is the police response, and they're not, as we all know, a homogenous group. And I break them down into a number of categories. First, the police on the ground dealing with protests, and other people's experience of that will be as good as mine, or their judgment will be as good as mine. But my impression is that the police response is quite subjective. Some are quite supportive of actions and sympathetic. And I think in the early days of XR protests, officers on the ground were supportive and actually were criticised for that. At the other extreme, I think it does happen more and more often, people know this better than I do, they can be really aggressive and covert about it. They cover up their identity, badges, their names, their numbers, they use pressure points, so they use force to try to break up protests, and that happens more and more, and is one of the problems with the policing on the ground. And at the police station, the fact of arrest is often used as an intelligence gathering tool. So, for example, people ask for their phones, names and addresses, PIN numbers. If people voluntarily hand them over, will be tricked into that, and they can access the phones for their database of activists. And no doubt all of that material will be compiled and kept and used to try and challenge protests in the future. And similarly, people arrested for serious offences, so that the police can justify taking DNA samples and fingerprints and so on, whereas people lying on the ground shouldn't normally have that done to them. Another category of the police, obviously, is the police command, and as people know, there's a specialist unit at New Scotland Yard and their supervisors, and they were found wanting in applying Section 14 notices banning protests during the recent XR protests, and during the course of that you saw a glimpse of the desperation in some cases of the higher levels of the police to try to stop using so-called lawful notices, stop XR protests. They were so desperate they got it wrong. Judicial review of their action and their decision was upheld, and hopefully civil proceedings will justify and put back in a good place the people who are affected by that. And then obviously there was the Undercover Police Inquiry, which was set up 5 years ago, and in November of last year, started hearing evidence of undercover policing from the 1970s, and others will be able to judge as well as I do what that's going to reveal, but you already get a flavour for the high-level discussions amongst the police about how to clamp down on what they categorised as subversive protests, which led, in their eyes, justified deep surveillance of activist communities, mainly on the left or anti-authoritarian wing. And you get glimpses about what's going to come out already. I've mentioned there in the brief note the Ratcliffe Power Station case, where activists shut down or sought to shut down a coal-fired power station. Their plans were affected or led by an undercover police officer, Mark Kennedy, and the Court of Appeal, the Lord Chief Justice, made very damaging and critical comments of the police about how they'd taken action, and the police and the prosecution failed to disclose really key material, which led to the convictions being unsafe and therefore quashed. It's a glimpse of what may come out in the Undercover Police Inquiry, and we've also seen that in the horrific and egregious use of relationships by male officers against female activists. For what end, who knows, or what justification, who knows. But it's a flavour for the desperate measures that the police will take, particularly when they don't think they're going to be held accountable even, their actions will see the light of day. That's what they'll get up to if they're given a chance. We're going to page 2 of the note, and just again romping through things. The prosecution, the Crown Prosecution Service, activists are often accused of using court cases in extension of protests. As I see it, the prosecution and the police authorities see court proceedings as an extension of their efforts to try to suppress protest. They bring prosecutions which would normally, if it wasn't a protest case, would be NFA'd or some out of court disposal. They use the law in their eyes imaginatively, and I've mentioned there the Trade Union Labour Relations Act, which is used against activists since the 1990s. My first experience was at the Preston bypass, and a bit like a virus, it spread around the prosecution authorities, popping up here and there. But this case of Ivan Todd, which I mentioned, is one where the High Court said that although it sounds like an industrial relations prosecution or charge, it can be used all over the place, even in environmental activism. Similarly, as the prosecution tried to play the political game, they tried to reduce the value of damage in criminal damage cases to under £5,000, which, as many people know, is the threshold for the right of the defendant to a Crown Court trial. And so, just a flavour of what they'll get up to, you can see how the police will be very happy to see quotes of £4,990 for the value of damage, so that they might get, in their eyes, a more sympathetic hearing for the prosecution case in the magistrates' court. Then going on to the court, I mean, they're very happy to go along with the police and prosecution tactics. You see that before RUI, released on investigation, became current and might now be fading. The use of bail conditions as a state injunction to stop people from associating with other activists not to go to protest sites really is a device to suppress protests during the currency of a court case. And with COVID, those court cases can go on and on and on. And bail conditions, if they apply, can be really quite excessive in suppressing protest. And then the deal, which is, again, back to Lord Hoffman, sentences. Lord Hoffman sets out a trade-off, and I've set out in full the quote from paragraph 89 of his judgment in the House of Lords, which is often cited. It's got good bits and bad bits. The good bit for this is that conditional discharges, in his view, should often be seen as the starting point for sentences in many protest cases. But that's part of a deal where he thinks that people should plead guilty, even if they've done nothing morally wrong, and they should play by the rules. And if they do play by his rules, then they're supposed to get these sweeteners, these lower sentences. The cases have been more sophisticated since Hoffman, and I've cited the Court of Appeal case of a Preston anti-fracking case, Robertson Blevins, where the Court of Appeal applied a more sophisticated approach to sentencing in protest cases. But the themes are similar, which is if your actions were taken for political protest reasons, then you can often get a lower sentence and can often avoid prison, though it's not ruled out. And then finally, business and the government. In the criminal justice system, we don't see that so clearly, but it does exist. Others will talk about injunctions. I've mentioned there examples of the police and business getting together to compare and share information and intelligence. And that goes back, for example, to the Undercover police inquiry, where the economic lead in the Consulting Association, which were business databases of activists, were used to compile lists of activists and trade union activists to blacklist them or to penalise them. And the suspicion is that for blacklisting of trade unionists and for the so-called green listing of activists, there was a sharing of information between business through the Economic League and the Consulting Association on one hand, and the police on the other. And that may come out, and many people think that that's been what's been happening for years and years and years. Business being in hand in glove with the police, sharing information, because in their eyes they have the same common enemy. And then finally, government and the law. Again, goes back to the Undercover police inquiry, where the evidence is becoming clearer that at the highest levels, not just on the ground, at the highest levels of the police, special branch, and of the government, they get their heads together about how to suppress challenging, in their eyes, subversive, but I see it as effective protest, because the status quo and law and order, or rather order, is what they're most interested in. And we've seen even now, even yesterday or the day before, the final remedy which the authorities have, which is to change the law, change the ground rules. And that's why we know about the review of protest law, which is supposedly taking place at the moment through leaks from the government and similar. And that goes hand in hand with the so-called demonization of protest movements by the supportive elements of the press and their press statements, increasing intensity coming out. I think it's the Daily Telegraph just the other day, where protest movements were demonized. And no doubt the Human Rights Act would be under challenge, as well as new laws. And I mentioned there a couple of the set piece acts of Parliament where protest law was reviewed and solidified through the Public Order Act and the Criminal Justice and Public Order Act. But on a positive and final note, I think where the police and the government and the authorities look to change the criminal law, it's a massive compliment to the effectiveness of the protest movement, that they've got to change the whole of ground rules in order, in their eyes, to seize back control. And in the case of the environment, of course, the aim is not necessarily to win the law, but it's to save the environment. And it's a measure of the success the environmental movement's having, that the government is prepared to change the law. And so it should be seen as an accolade rather than as a challenge or dispiriting that the law may be changed in the coming months and years.
Well, thanks very much, Mike. And it's nice to end on a positive note, because, of course, if protest was ineffective, there'd be no need to change the law. So it is a testament to the efforts that people have been putting in, and the benefits, that the real victories that have been won. So moving on from Mike, we're going to now hear from Rajiv Menon, who also is involved in the undercover police inquiry. And he's going to tell us about some of the, well, as I said earlier, about some of the responses to police tactics, and particularly what defence advocates might want to do in protest cases. So I'll mute myself, and Rajiv, the floor is yours.
Thank you, Stephen, and hello, everybody. The importance of defending the right to protest in a democratic society cannot be overstated. However, as Mike's talk has made clear, defending protesters against the might of the British state can be challenging, to put it mildly, because the simple fact is there is no equality of arms, and never has been, between the British state with its infinite resources and the individual and his or her legal team and supporters, particularly in the magistrates' court. At the end of the day, the battle between David and Goliath is such an intrinsic part of our adversarial criminal justice system, particularly when it comes to the prosecution and criminalization of political protest. Now, having made that generalization, it's important to recognize that defending protesters in the early 1990s, when I first qualified and Mike first qualified, was very different in several important respects to defending protesters today. And we need to acknowledge those differences so that we can learn from our history and improve our response to the state's constantly mutating and increasingly repressive approach to protest. Now, obviously, I cannot in 10 minutes do justice to 30 years of protest history and the state's response. I have to be selective. So I'm going to focus on 4 matters. They're all different. They're not more important than other matters I could have spoken about. They're just simply 4 things that I thought may be interesting, that are particularly important, both when looking backwards and when looking forward. And they're relevant not just to environmental protest, but protest more generally. And the first matter is the state's obsession with creating more and more criminal offenses and passing more and more laws that restrict the right to protest. Every recent prime minister, from Harold Wilson to Boris Johnson, whether Labour or Conservative, has criminalized more and more human behavior. Consequently, the political space in which the citizen can protest has been systematically shrinking year on year. We know from the Undercover policing inquiry that the state's response to political protest began to change fundamentally in 1968, with undercover police officers being used to infiltrate progressive organizations deemed subversive by the state. We know from Margaret Thatcher's attacks on trade unions and workers' rights in the 1980s and the Public Order Act 1986. These were also important milestones in the history of the state's response to protest. Nevertheless, by the early 1990s, the nature and extent of criminal offenses and laws available to the state remained reasonably limited compared to now. When I was starting out and appearing in the magistrate's court and then later in the Crown Court, I represented people facing obstruction of a police officer in the execution of his or her duty, assaulting a police officer in the execution of his or her duty, common assault, ABH and GBH in more serious cases, public order offenses from disorderly conduct and threatening behavior to affray and violent disorder, criminal damage, and in some rare cases, weapons offenses. But that was basically it. And there was a very limited use in those days of civil law as part of the state's criminalization strategy. The Criminal Justice and Public Order Act of 1994 was, in my opinion, the game changer. Although this statute is best known for allowing adverse inferences to be drawn from a defendant's silence, its primary purpose as a piece of legislation was to clamp down on unlicensed raves, hunt sabotage, anti-road protests, squatting, and the rights of travelers generally. It created various new criminal offenses, including aggravated trespass and trespassory assembly, and aggravated trespass in particular, as I'm sure most of you, if not all of you know, has been ruthlessly deployed ever since against protesters of all kinds. And that trend, begun by the 94 Act, has continued ever since. There are many, many more offenses that have been created in the subsequent 30 years and subsequently deployed against protesters, including harassment offenses, terrorism offenses, and regulatory offenses. The list, quite frankly, just goes on and on. And the length of custodial sentences has been on a continuous upward trajectory as well, despite the fact that overall levels of crime in Britain have been falling for decades. Additionally, civil orders and injunctions, others will speak to this in more detail, have been increasingly deployed to restrict and control protest. The worrying phenomena of the state and some sections of the media effectively equating protest with antisocial behavior has become almost normalized. As a counterbalance to all that regressive legislation, we did have the Human Rights Act in 1998, which has offered some protection for protesters. But overall, the picture, and I'm sorry to be bleak about this, overall, the picture as far as the state's response to protest is concerned is pretty grim. And despite the victories that have undoubtedly been there, particularly victories before juries, some of which Mike has spoken about, I don't think we can pretend otherwise as far as that general picture is concerned. The second matter I wanted to speak about briefly is the exponential rise in mass video surveillance. I remember when I first moved to London in the late 1980s, before I qualified as a lawyer and became involved here in anti-racist and anti-fascist activism, how there was no CCTV to speak of. The police had officers with handheld video cameras attending and filming some protests, but that for the most part was the extent of video surveillance. Today, Britain has one of the highest per capita rates of video surveillance in the world, almost certainly third, in fact, behind China and the United States. It is estimated that there are around 6 million CCTV cameras in Britain, and that number is increasing daily. Pre-COVID, the average Londoner was caught on CCTV camera about 300 times every day. There is no question that mass video surveillance has fundamentally changed the landscape as far as the state's approach to criminal prosecution is concerned. The vast majority of criminal cases these days, not just protest cases, but criminal cases generally, involve CCTV evidence. Now, some might say, perhaps not many in attendance today, but some might say generally out there in society that mass video surveillance is a price worth paying in the fight against crime, particularly serious and organized crime. And there's no question that but for CCTV, some crimes would never have been solved. However, there is a far more sinister side to the continued growth of the surveillance industry, as many excellent campaigning and non-governmental organizations, NetPol being one notable example, are at pains to warn us. The implications for our fundamental rights are stark. I fear that as a society, we are literally sleepwalking into a brave new world where more and more of what we do in our daily lives, even within the confines of our own homes, is being recorded and monitored by a state obsessed with surveillance and control. I genuinely do not believe that this is an exaggeration. And that's before one even begins to factor in the role of social media and companies like Facebook and Twitter. I have no doubt that those of you battling at the cold face, both activists and lawyers, will know exactly what I'm talking about in terms of surveillance overreach. The third matter I want to speak about briefly is kettling. Kettling, as you all know, is the containment of a group of people in a confined area. And it was in the late 1990s that the actual word kettling came into more common usage, even though the police had been kettling protesters in one way or another for years, most notably during the miners' strike, Orgreave and elsewhere, the print workers' strike in Wapping, and of course the anti-poll tax demonstrations in the early 1990s. Kettling has since become a regular feature of the policing of demonstrations, particularly larger demonstrations. And it's difficult to explain if you've never been kettled, not only how irritating and frustrating it can be, but also how frightening and even violent it can be. A kettle is not just a cordon around a crowd. It is not, as the police often and falsely suggest, the least intrusive and most effective of available public order tactics. What the police frequently do is squeeze the space, quite literally, and behave in an aggressive manner. They use their full armory, including their batons and their shields, to intimidate and, on occasion, to assault protesters. And as time goes on, and it's often hours that you're stuck in these kettles, often hours, the atmosphere becomes increasingly tense and increasingly coercive. And this, I'm afraid, is part of the purpose of the kettle. Kettling is an anti-protest tactic designed to disincentivize protest and, for good measure, gather intelligence on protesters, whatever the police, the state, and the courts might say to the contrary. Now, there have been various challenges, of course, to the legality of kettling, notably the case of Lois Austin and others. Now, although both the House of Lords domestically and the Strasbourg Court in Europe ultimately held that kettling was not in and of itself a deprivation of liberty, contrary to Article 5 of the European Convention, there was at least a recognition of sorts that certain preconditions had to be established for kettling, for containment in that manner to be lawful. And so we've seen this trend emerge and develop over the past 20 or more years. And finally, as far as my four points are concerned, what I'm calling protest in the era of COVID. Now, others will speak about Extinction Rebellion and Black Lives Matter and how these two movements in particular have had a significant positive impact on protest in Britain and have so intelligently adopted and adapted to contemporary policing realities. I want to briefly talk, and perhaps more controversially, about something a little different, namely that the policing of anti-lockdown and anti-vaccination protests since March of last year, although this is probably not a political cause, close to the heart of many of us attending tonight's webinar. And that, in reality, let's be honest about that, this explains why the civil liberties community, the left, and progressive lawyers generally have been for the most part, been somewhat slow to respond to the undoubted abuse of power by the police and the state in the name of fighting COVID. There is no question that the government has used COVID as a justification to restrict civil liberties generally. The Coronavirus Act of 2020 received royal assent on the 25th of March last year after virtually no parliamentary scrutiny. There have also been many others, dozens if not hundreds of other statutory instruments and regulations passed by ministers. Collectively, this body of COVID law, this impenetrable mess, has granted the police emergency powers to restrict and prohibit public gatherings and impose draconian fines of up to £10,000. There are stories galore, many of which have barely been reported by the press, of basic rights that we've been taking for granted for years being denied, if not trampled. Protesters being arrested for non-imprisonable offenses that should be the subject of fixed penalty notices, being kept in custody for up to 24 hours, whilst their phones and laptops are interrogated for intelligence gathering purposes. Some protesters who were assembling outside in groups of less than 10 people. Meanwhile, jury trial in closed, unventilated courtrooms is apparently safe and lawful. And the contrast is stark. Bail conditions that ban attendance at protests being imposed, criminal behavior orders following conviction for those minor trivial of offenses, often regulatory, being imposed, some of which ban attendance at protests for years, some of which ban using social media to advertise protests. This is the reality. This is ministerial law, unchallenged by an acquiescent parliament, and I'm afraid a rather hopeless opposition. And the police are taking full advantage. The new Tier 4 coronavirus regulations that came into force in January this year go even further. They ban public gatherings of more than 2 people from different households in most circumstances, and there's no exception at all for those attending protests. And I'm afraid whatever the politics of those involved in this activity, we ignore what is happening at our own peril. Whatever our views about the conspiratorial politics, the fundamental rights of these individuals and these protesters must, in my opinion, be defended. And I end, as far as that is concerned, by just reminding everyone of the famous Martin Niemöller quote. I don't need to go over the details, I'm sure you all know it, but we have to remain vigilant. We can't simply turn a blind eye to what has been going on in the last 10 to 12 months during the era of COVID. And so in conclusion, I return to where I started by generalizing about the importance of defending the right to protest. In my opinion, there are going to be, and there have been, very few slam dunk victories for activists or lawyers. We have to keep taking those small steps and keep chipping away at the edifice of the state's criminalization of protests. We have to continue to defend fearlessly. We have to continue to raise every arguable legal point. We have to continue to expose every miscarriage of justice. We have to continue to campaign and support one another. We have to continue to mobilize and grow our movements. And when there is a great victory, like the recent victory of the Stansted 15, who had their convictions quashed, we have to pause and take stock and celebrate and learn the lessons before jumping straight back into the arena and continuing to defend the most fundamental of our democratic rights, namely the right to protest. I hope I haven't gone over my time limit by too much. Thank you very much.
Well, thanks very much, Rajiv. Ending on a stirring note. I'm afraid my weak chairmanship means we are going a bit over time, so I'm going to press straight on. Mike Schwartz has got to leave at 6, so I think we'll deal with the question that was put on the chat for him among the other panelists, or he can have a look at it and deal with it in writing. But we're going to move now to Stephanie Harrison, who's going to pick up one of the threads that Rajiv had on the use of of civil injunctions against protesters.
Yeah, so going along with the theme of 30 years, I have to start with my own very first experience of being subject to an injunction brought by my university when I was in first year at university, protesting against a professor who we said was racist and sexist, and he certainly was. And so that was my first rub up against how your rights to protest can be curtailed by an injunction. For me, it was the beginning of my career, because I was fortunate to be represented by Vera Baird QC, and who's not at the time now a QC, and I thought, hey, that's a great job. I'd like to do that, because you are in a position to be able to articulate some of what Rajiv and Mike have said about the critical importance of individuals being able to express their views and to oppose and to resist policies and practices and laws that are wrong, and which we don't always want to wait for history to tell us that we're wrong. We want to be able to say it loud and clear at the time when those abuses are taking place. So that was 1985, 86. And my next experience of injunctions was as a barrister, beginning in 2005, when I think that there was a very clear concerted step taken in collaboration between both the police and private companies, in particular companies involved in experiments on animal rights, to use the civil law as a means and a supplement to what were already, obviously, from what you've heard from both Mike and Rajiv, very extensive police powers. And they used in particular the Protection from Harassment Act, introduced in 1997. So why did they think this law was useful to them? Primarily because it allowed for a power of arrest to be attached to civil injunctions. It also allowed for conduct that wouldn't be criminal in the context of the criminal law, however widely it was drawn. Here under the civil injunction regime, conduct that was not going to be prosecuted could be then the subject of injunctive civil relief. And of course, the other benefits to companies and to the police of the use of this form of constraint was that it didn't take place in the criminal courts. It didn't have to cross any threshold of public interest. It didn't have to cross any exacting evidential threshold. You invariably were faced with individuals who did not have legal representation, didn't have legal aid, and were therefore unable to effectively defend themselves. It also allowed, critically, and this is the key element of why civil injunction proceedings have been used, the ability of companies and indirectly the police to take preemptive action. That's always the biggest challenge for authorities when it comes to protest. If it's enforcing the criminal law, by and large, they have to wait for action to take place. Of course, there are powers that are preventive, but they're less able to be used by the police. As far as an injunction is concerned, it's perfectly orthodox to have proceedings brought on the basis of impending or imminent alleged unlawful action. So you can take action against future conduct before it actually takes place. And you can also do it in ways in which you don't have to bring a case against a particular named individual and prove a case against them. In the harassment injunctions that were being pursued from around 2005 onwards, the claimants sought to bring proceedings against representative bodies, usually disparate groups of individuals who came together in campaigning groups, and they would sue the group in order to bring into liability everybody who could be said to have associated with that group, so that you got control not over a single individual or groups of individuals where they could prove a case, but preemptively against wide-ranging potential people who hadn't committed any wrong, and there was no real evidence that they were going to commit wrongs either. That process of suing against representative bodies resulted in very wide-ranging injunctions that were being backed up by the ability, if they were breached, by people who had not been before the court when they were made, through arrest by the police. It took us about 3 years to unpick this series of cases that were brought primarily against animal rights activists, but then sought to be extended into environmental protests and anti-arms and protest against the use of arms in conflicts like Palestine and Iraq. And in that context, we were able to effectively end the use of this form of order that had been obtained largely against unrepresented individuals. However, that didn't stop the police and other corporations later coming up with even more extensive mechanisms to seek to use, again, civil injunction proceedings. And that most recently has been from 2017, when a company that you may be familiar with now because they have their names blazing on the previously Sky cycling team, Ineos. They also have a very large and very filthy polluting factory in Grangemouth in Scotland, and they're owned by the richest man in Britain, Mr. Jim Radcliffe. So he decided to invest his very, very deep pockets in once again seeking in 2017 to use in civil proceedings to regulate and to control and to suppress the protests that were taking place in respect of fracking and the use of other forms of unconventional extraction of fossil fuel, which obviously is so damaging to the environment and a major contributor to climate change. So in 2017, Ineos sought what they described themselves as the most extensive injunction ever granted, and it certainly, or ever sought, and it was ultimately granted by a judge sitting in the Chancery Division of the High Court. And it this time didn't even pretend to try to identify any named individuals or even groups who they said were acting unlawfully. Instead, the entire injunction was brought against persons unknown. Consequence of that was that it applied effectively to each and every person, potentially on an indefinite and indeterminate basis. It covered classic torts such as trespass and private nuisance, protecting the right to enter on and off their sites, but also went much further and was an extremely wide-ranging injunction over the public highway, recasting the right to protest on the highway, banning forms of symbolic protest like slow walking that had been used as an effective mechanism for drawing attention to and resisting the activities of the frackers and their supply chain, and even further had a persons unknown based on economic torts of conspiracy to injure, which it has, unlike anything that's to do with the land or the public highway, has no limit at all. So basically anywhere and anyone in the country who is involved in activities that could be seen to interfere with and damage the economic interests of those involved in fracking, including Ineos, could potentially be caught by this injunction. And that latter part of the injunction was brought on behalf of the entire supply chain of companies that could be supporting these fracking activities. And what they were primarily aimed at was individuals who organized campaigns against their activities. The evidence criticized Friends of the Earth, Greenpeace for distributing information that they said was misleading and lying about fracking. It focused on local campaigns that were challenging what they were doing, people writing letters seeking to get companies not to participate in fracking, letters done in perfectly reasonable way, simply pointing out what the consequences were. That was the extent of this injunction, and in no uncertain terms, it was said to be an attempt to end direct action protest, but it went very much further than that. And its primary aim was to cause a huge deterrent and an enormous chilling effect on the willingness of any individual to participate in these forms of protest against fracking. A High Court judge was prepared to grant that order. That then followed with several other orders in very similar terms, which were in fact then overturned by the Court of Appeal in 2019. The Court of Appeal in INEOS Upstream drew back the injunction to what is a more common form of injunction based on trespass and nuisance, and was highly critical of the extensive nature of the order that was made, including against persons unknown. Subsequent case law has now very much further limited the utility of persons unknown injunctions by saying they're not possible to be brought as part of any final order. However, they can continue to be brought on an interim basis, albeit only in respect of the classic torts of trespass and private nuisance. So what did they seek to gain by that? All of the things that I'd said, but in addition, the consequences for the fair trial rights of individuals where they are subject to an injunction brought by persons unknown cannot be underestimated. Essentially, an order can be made of which you have no prior notice, you have not participated, but if you were to subsequently breach this order, it would be enforced by contempt proceedings. And so activity that might involve obstruction on the highway or a lock-on, the sorts of conduct that might result in a conditional discharge or a small fine can instead be enforced through civil proceedings with a penalty of up to 2 years imprisonment and very large fines. But more of an impact, generally in practical terms, is the liability for very large costs. And in the cases that were brought by Quadrilla, which was the company at Preston New Road who were involved in fracking until it was stopped early last year, they were seeking costs in the region of £50,000 for interim applications. The deterrent effect of using civil proceedings and the oppressive nature of the liability to costs is a huge element in the armory that the companies use. And so it's an area where we have to continue to be vigilant. We are fighting a war of attrition. The companies have very much been pushed back in recent times, but just as Rajiv said, the companies and the state and the police are inventive in their in their responses, and then equally then so will we. But it is a long, hard struggle, and in between the 3 years that it's taken to end these forms of injunctions, protests have been prevented. Many individuals, particularly in local groups who support the activities, are involved in the campaigns at a lawful level, are terrified of being found to be in breach of the injunction, and they stop their protests. That's an uncalculable, unquantifiable consequence of these methods that are used. And just finally, in terms of the relationship with the police, there is no doubt that companies and the police have operated hand in glove in seeking to use these forms of impermissible orders. We know from the cases that we've done going back to 2005 that the police have been instrumental in providing the information. They provide lists, they provide the intelligence, and they provide the evidence. They do that often undercover, but also they provide formal witness evidence, but never come to be cross-examined in the case. They also do provide the backup in terms of enforcement. And one of the critically important consequences in terms of the relationships between criminal and civil law is that a civil injunction can be prevent what would otherwise be lawful activity. It can also draw the line between where the boundary is of lawful and unlawful protest. And very often, certainly in the context of the anti-fracking protests, the activities on the ground that the police were having to tolerate, sometimes facilitating it, but sometimes aggressively policing it, but which they had to tolerate, the civil injunction was then used to redraw that boundary. And then the police's action changed, and they would move to prosecute and to arrest and to later charge in a way that they hadn't done before. So there is a pernicious relationship between the use of civil injunctions and prosecutions. But ultimately, the Court of Appeal in the most important case to date, and the leading case, which is a case called Canada Goose, has made it clear that the blunt tool of civil proceedings should not be used in favour and as a substitute for the criminal law. That may not be, from what you've heard from Mike and Rajiv, much comfort, but at least the criminal law is imposed by Parliament after debate and through a democratic process. The unrestrained, uncontrolled actions of private companies are not. They do not have to be accountable to anybody save their shareholders. But what we do know, and what is important to recognise, is that the activities of individuals bravely continuing to advance their views, their opposition, does impact on their share prices. And if that's where it hurts, and that's what can bring them to account, then I can certainly say, from working on the anti-fracking and the recent UCOG case, the willingness of individuals to continue to protest despite these very serious intrusions does impact in that way as well.
Yeah, well, thanks very much, Stephanie. And it's important to say that that thanks to a dogged practice of resisting these persons unknown injunctions, that actually it has been cut back quite substantially, largely down to the wily tactics of Steph herself. So it's not that is an area of real concern, but one where there is room for optimism and hope. Now, we are overrunning. It's now Paul's talk, and I'm just going to not say any more so that he can tell us what he's going to say.
Thank you. I'm going to talk about the intersection between being a lawyer and an activist and protester. So please, nobody send this presentation on to Priti Patel. I'm going to be adopting the distinction that Mike Schwartz, I think, mentioned between protests sort of on the street for wider political change and protests and direct action to directly protect nature. So on the first one, I want to talk a bit about my experiences with XR. And the first time I ever heard about XR, I got a Facebook message from a really random guy, and I mean random in every sense, in June 2018, asking to go for a coffee with me to discuss the climate crisis. And we went to the Pret opposite the Royal Courts of Justice, and we're both quite fast talkers, and we both just sort of erupted to each other for hours, just talking about the crisis and how it intersects with the legal profession and politics. And we came up with the concept that really the climate crisis is the greatest crime in human history. And that person was Roger Hallam, who's the founder of XR. And I still have no idea how he got my contact details or why he messaged me. But it was very interesting chats, and I was sort of hooked from then on. And I went to the first Declaration of Rebellion and made that declaration in October 2018 and symbolically occupied the road with George Monbiot. And then I went to the April Rebellion, which was, I think, the best protest, act of civil disobedience, whatever you want to call it, I've ever been to. But when I was dancing around the pink boat, which is actually, I think I ran into Stephanie there as well, if I remember rightly, who was at the protest with her daughter. As well as dancing around the pink boat and hanging out on the beautiful garden bridge at Waterloo, I realised that XR, or the movement behind XR, goes deeper than just going to a protest, or even as a lawyer just offering to represent XR people or do their legal work. The key thing about XR is that the crisis that we face with the climate and the ecological crisis goes into every part of society. And I remember in April seeing the doctors there with their own stand and different professions starting to crop up with their own actions. And I realized that the legal profession needed that too. And so I got together with other lawyers. And by the time of the October Rebellion, we had our first action. So Lawyers for Extinction Rebellion was set up, and we had the All Rise for Climate Justice outside of the RCJ. Here's a quick picture. We actually drafted our own Declaration of Rebellion. And unfortunately, it's a really beautiful, powerful document. And I think you can find it online, or if not, I can actually still got quite a few hard copies I can send out. And unfortunately, I won't be able to read too much of it because Stephen will send me angry messages running over time. But it's, I think, a well-written document that really summarizes in passionate terms, or rather makes a call in passionate terms for the legal profession to properly react to the climate crisis. I'll just read you the final paragraph. In humanity's darkest hour, we have forgotten our power. We wish to re-establish lawyers as powerful storytellers with the intelligence, imagination, influence, and courage to shape the world around us according to our principles and conscience. We hope that you will pause with us and consider what you want the lasting impact of your life and work to be. We invite and urge you to join us in this rebellion. As it turned out, actually, this very protest, which was in many ways the archetypal free speech protest, we had lawyers specializing in climate change there making speeches, all very peaceful, all very non-disruptive, was actually illegal at the time under the Section 14 order made by the Met Police. But luckily, we didn't, of course, know about those conditions at the time the protest was made, so we weren't committing criminal offence. And as it turned out, that Section 14 was also unlawful. And since that launch, we have in Lawyers for XR continued to try to bring those principles to our profession in lots of different ways. So we had our first proper direct action outside Slaughters in May last February to protest them acting for oil companies. And we had our first sort of more gnarly for lawyers anyway, direct action in September 2020, where we symbolically obstructed the highway outside the Law Society to call on our professional bodies to take the climate crisis seriously. And since then, the Law Society has actually acted on that and really engaged with us. And the Bar Council have been more disappointing, I would say, refusing to even set up a committee in relation to climate change. And more fundamentally, refusing to see the ways in which the climate crisis will impact our profession. It's not just about chambers recycling more and turning off the lights. It's about asking the question, where is the money coming from? And in whose interest is the bar as a whole acting for? And that might mean killing some sacred cows. For instance, although the cab rank rule might have a place in legally aided parts of the profession, such as crime, in the civil profession, the fact that there's no or very little legal aid means that by and large, the bar is acting in the interest of those with money. And the interest of those with money is at the moment in advancing the climate crisis. And so if it were found that the bar was on average acting significantly more for those causing rather than those trying to stop the climate crisis, which I think is probably likely to be true, how do we as a profession respond to that? And that is what I, as an activist and a lawyer, am really interested in, and how we can marry up that sort of protest out on the streets, as we have done with Lawyers for XR, but also asking these questions in the profession and sort of spurring on debate. And I'd say as well, in terms of what lawyers can really do to support a movement like XR, obviously, there's lots of different ways. Audrey's doing amazing work representing XR activists in the courts. We also need lawyers who will talk in the media why we shouldn't abrogate the right to protest and also fight it in the legislature. We've got potential legislation coming up to reduce the right to protest and to strengthen the government and the police's powers. We need lawyers to resist that. But also, I would say that in the face of the biggest crisis probably in the history of humanity, definitely within our lifetimes, we need lawyers to stand up and start saying within our own profession, how do we want to do things, and how do we as a profession react to this crisis? That was a bit of a run through in relation to that, but I'm also happy to answer any questions you have about Lawyers for XR and that kind of thing. Moving swiftly on to what I would call the direct action side of things. And this is actually in some ways, I think, the thing that I find even more important in my work. Back in 2017, I was just a reasonably ordinary civil commercial barrister finding my way at the bar and earning some money. And I fell in love really with nature in my ordinary life, and spent quite a lot of time planting trees. And if you've ever planted trees, you'll quickly learn that you really want to protect the existing trees, because like the trees you plant, the saplings really die quite a lot. And even if they survive, it's quite frustrating because they're quite small for quite a while. And so you're sort of planting these tiny trees, which will take your lifetime to get to anywhere near a big size. And you suddenly think, actually, we really need to protect these precious gifts, these trees from the past that are already here. And so I wanted to do that. And I didn't really know where to start. So I asked around on Facebook and got directed to the people in Sheffield. I don't know if many of you know about what happened in the Sheffield tree crisis, but effectively the council were trying to chop down 17,000 street trees, and local people rose up to resist. And I got involved with them when the police were using a trade union law, Section 241, which I think was in Mike Schwartz's talk earlier, to try and arrest people for standing in their own front garden to stop the tree felling, which was completely unlawful and outrageous. And they knew it was unlawful, but they didn't know how to do anything about it. And they wanted a QC's advice, and I wasn't a QC, but I offered to write it over the course of a weekend, and basically wrote an advice saying why this action was unlawful by the police. And they handed it to the police, and the police went away, and their campaign continued, when actually at the time it was almost about to collapse. And I think there's something very interesting there, which is that as lawyers, we often see our role at the end of the process. So, for instance, all these people who got arrested did eventually get civil damages for the arrest, and obviously their criminal prosecutions were dropped, which is where we normally see our role, that end of things. But of course, in this instance, if we'd have waited for that, those trees would be gone. Thousands and thousands of irreplaceable trees would be lost. And so it was really important then, as an activist lawyer, to intervene at that point. And I think it still remains the piece of work that I am proudest of, and which I think has had the greatest impact. I can't really, I think as an influence in my job, helping to save thousands of street trees for me is a really wonderful thing. And this is an example, this is using private security and the police we can see in this photo to surround trees to chop them down, which is again an example of the kind of nexus between those two forces that we're increasingly seeing. But the next photo, this is on the same street. All of these cherry trees were due to be chopped down, but most of them were, as a result of this campaign, which lasted 2 years, saved. And this is a photo I took when I went there. I just want to put that because it's really beautiful and shows, I think, what we're fighting for.
Well, Paul, can we wrap it up on that beautiful note, or is there something?
Can I have 2 more minutes?
Yeah, carry on.
Okay, I just want to sort of very quickly sort of gamble through how else lawyers can be of assistance in these instances, because again, many lawyers sort of see their role as winning each individual part of the case. And I went on to represent the Sheffield street tree protesters, and lost many of the cases that I was doing for them. But these were all part of a greater campaign. And each time that a campaign, the case was lost, it was then used by the protesters very skillfully to drive their campaign forward and to get greater support. So I represented one of the tree protesters who basically went against the civil injunction, going back to Stephanie's talk. He was being charged with contempt, and he very skillfully used that, even though he was found guilty, to drive support to the campaign. And the end result was that after, I think, nearly 3 years of campaigning, although in almost every legal sense the protesters had lost, the council backed down, and all of these 17,000 street trees were saved. It's probably one of the biggest victories in environmental protesting. And it's really interesting to see that sort of interaction between the law and how lawyers really need to, I suppose, engage with activists and not only look at winning each individual case, but look at that broader picture and that broader campaign. In relation to the representing that protest and injunction case as well, I offered my services pro bono, and after outside of court, he said he wanted to pay me, and I said, you can pay me in trees. So he got a crowdfunder going, and he raised, I think, over £1,000. And we planted loads of trees around Sheffield. So I think I am the first barrister to be paid in trees. One final thing, there's so many examples of how lawyers can really, by getting involved in campaigns, obviously maintaining their professional standards and maintaining their legal obligations, by really getting involved with campaigns from the start and making effective interventions can really help. So another injunction case, the Happy Man Tree in London. I kind of really want to finish on this as well, because it's every lawyer's dream to have a case named after them, I think. So now they luckily put me as the first defendant. So I'm now searchable in all the legal databases in this injunction case. Very much also showing the overreach of injunctions, because I was personally named just for visiting the trees a few times to actually talk to the protesters. But again, although I think the injunction was used here to try and stop me representing the protesters, actually it didn't really work, because in the course of my personal negotiations with the other side to make an undertaking, I managed to get a wider injunction that allowed for some forms of protest, and was very effective over the next few months in actually allowing protests to carry on outside the tree. And then my personal undertaking was then used as the basis for the whole order. So even though I was actually stripped of my role as a lawyer, I could still do something. And although in very sad terms, the Happy Man Tree saga didn't end well. That's a picture of the tree just after felling, taken by me. I was there. As with all these things, we must look at the broader picture. And that campaign, especially as the Happy Man Tree was made Tree of the Year, was a real, I think, galvanizing force for many people to stand up for our street trees and take peaceful, direct action to save them. And I saw that image, and I was there with the protesters who'd spent, I think, nearly a year trying to save it. And we were hugging each other, and many people were crying. And obviously it's deeply sad, but seeing that made me want to do what I can as a lawyer and as an activist to try and protect nature and to assist those protecting the natural world. And
right, well, thanks very much, Paul. Yeah, that's an optimistic note on which to end, with what we can do rather than what we have to confront. And I'm not, in that same vein, I'm going to move now to Audrey Cheryl Mogan, who's going to tell us about some of the tactics to use in criminal prosecutions, and in particular the things that lawyers can do to influence the way in which cases are listed and the prosecution are made to conduct their cases properly, so that there's some practical, useful advice to a number of people who want to take activist positions on things.
Thank you, Stephen. Yes, so what I will be talking about is really some of the, it's kind of following on from a depressing theme. I'm not going to pretend it's the magistrate's court. It's depressing even when we're not talking about big clampdowns on protests. So, but I'm going to try to keep it quick because I know everybody wants to hear from Swan as well. I am a criminal defense and human rights practitioner and an activist lawyer. And thanks to Paul, also somebody who knows how to plant trees now as well. I've defended protesters, everyone from environmental protesters, specifically from people kind of defending like the smallest it's an amphibian, the great crested newt, which is also called the warty newt, to things like obviously Extinction Rebellion and some of the really Extinction Rebellion, HS2 protesters in the Roald Dahl Woods, who were up in there, I think until recently, in their tree houses, to Heathrow Paws, and everything beyond Extinction Rebellion, like beyond politics. So I'm not going to go through all of that. I'm just going to mention kind of 5 points, which I think kind of show a little bit about my experience as a junior criminal barrister and some of the trends that I'm seeing, which make me quite afraid. And I just think it's important for us to know about it and to think about how we could challenge it. So the first thing I want to talk about is just the sheer number of criminal charges that came out of these protests themselves. Kind of looking for figures, but some of the published figures are that during the Extinction Rebellion protests, about 3,400 people were arrested and about 1,700 people were charged. I know, and I'm sure Mike knows as well, and lots of people who find themselves in the magistrates' courts for, you know, about that year, that it seemed like that's all we were doing. It was huge numbers. That kind of, they were charges for summary only, low-level offenses. And I'm actually curious to even know why only half of the people were in fact charged and what those kind of decision-making processes went into that. So, I mean, the first thing is we know the science isn't disputed. I've already seen kind of the list on this of the audience. So I'm not going to go into any of that in great detail because clearly you guys know all about it. I've obviously got my XR book with me here as well. I'm sure most of you do too. But the big report, and one good thing that's come out of some of these summary only trials is in those trials, our defendants have been able to bring the kind of information they have with them when they're giving evidence. So including the IPCC report, which is a report put together, 91 authors from 40 different countries. Fact is, the science on climate change is just, it's not disputed. We know what's happening. We know what would be happening even in 9 years from now, the increase of 1 degree. And so it is, I find it quite concerning when you know that this is such a big issue. And as Paul has rightly said, one of the biggest issues that we're ever going to face, the risks to health, livelihood, water, food security, and again, as usual, impacting the global south and those who are already more vulnerable. And of course, I spoke about the great crested newt, biodiversity, and how that will impact the whole, oh my God, I'm so sorry. I'm so sorry. Obviously that would happen. Anyway, God, fingers crossed that person doesn't try to call back. But yes, what was I saying? The great crested newt, biodiversity, just the impacts are real. And I find it surprising that on one hand, we know the science is real. On the other hand, we know that there's a huge backlog in the criminal justice system because of COVID, the fact that the courts were closed for some time. And you know, it really has to be sensible decision-making processes. Is it really sensible to be dragging in individuals, people, your grandma, basically, or doctors or students, people who've never been in the criminal justice, by and large, people that would have never been in the criminal justice system before, in order to prosecute them for very low-level offenses which they're almost certainly going to get things like conditional discharges, when really it isn't the harm of their actions to the victims, it's the harm that would be done if these issues really weren't raised. Now, when the CPS consider the public interest, the Crown Prosecution Service, of course, they think about things, first of all, just because a prosecution started, it's never a rule that it has to continue to its end. And one of the things that they need to consider is, one, the cost, of course, to the wider criminal justice system. And again, it's some of the things that I already mentioned, like the likely sentence. And that is something I think is really concerning, because it doesn't feel like bringing 1,700 people through the criminal justice system when we know that this is a real issue, and how much the public interest test is really being looked at. I know I've done representations to discontinue prosecutions. I'm sure Mike's done them himself, but it seems that they're always going ahead. So I think, and two things. I kind of wanted to show you guys one quick picture. Now, this was after the Tower Bridge protests, which were about London air pollution. I think I can share my screen, if that's possible. And I think some of you guys might remember this, but this was the Mayor of London's ad campaign that came out at that time. And it was clear, it was just, you know, again, it's not disputed. So I'm just going to stop sharing right there. It's not disputed that there's a problem with air quality, climate change is happening. And in fact, after the April Rebellion, what happened? A climate emergency was called. So again, I've said it a million times, but I can't see how this meshes with one another. You know that what these people did was right, because they raised the awareness, they raised the alarm, and still bringing them into court. So that was my kind of first point, the sheer idea that you would charge hundreds, thousands of people for these kind of offenses. The second thing I'm going to talk about is actually what happens in the magistrates' courts. So my first point is kind of about disclosure, and that is always been troubling. And for those of you who might not be lawyers out there, it's a simple test. Basically anything that the prosecution has that could undermine their case or support the defense case, they must disclose. There's some exceptions, but we don't need to get into that in these kind of cases. And a lot of the people that were being arrested through the Extinction Rebellion protests were coming in for things, especially around the April protests, were for breaching Section 14 notices. And that really, when you're looking at that, that's a question about the decision-making of those officers. So disclosure and how those decisions are made is really, really important. And I can't tell you how many times in the process of magistrates' courts trials, we tried to make that argument, and how many times we were pushed back by judges. So, I mean, anybody out there, you don't have to do a defense case statement. You don't have to ask for this disclosure in the magistrates' courts trials. But if I'm going to give you a tip, you should, and you should keep pushing for that kind of stuff. But in the end, what is the factory farm of magistrates' courts? Having now done Crown Court environmental protest cases and comparing that and the way that it's dealt with the magistrates, it's really, really worrying and shocking, especially because about 95% of these cases will start and end there. The second thing I wanted to talk about was breach of bail. And I saw that somebody had written a question about that. And I have had HS2 protesters pulled in for breach of bail. And I mean, God, it's going to sound like my entire talk is so depressing. But if you thought the magistrates' court was bad, see a breach of bail hearing. It's literally no rules of law. Just everybody saying whatever they want to say. No rules of evidence, and then people just deciding. And I've seen in almost it's exact same bail conditions in different courts on different days, different benches, interpreting them in a different way. And even though that doesn't lead to a conviction, that could lead to the loss of your freedom. It's so significant. And to be honest, I've seen and been really concerned that some bail conditions have even been put in place that kind of circumvent, basically act as a way to prevent the protests in and of themselves. So anyways, I'm just trying to kind of go through this as quickly as possible. But yes, I just saw the question about breach of bail hearings, and I think that they are really problematic. And the way that bail conditions are phrased also has this kind of additional clamping down on the right to protest and people's protesting. Now, the autumn uprising, so kind of the October rebellion cases, listing procedures. So Stephen mentioned I was going to talk about this, and this is, again, something really problematic that I saw myself. Basically, what was happening was we were finding ourselves about every Friday, and most of you will probably know that, they were listing all the kind of first appearances for the trials, people who were arrested during the October Rebellion, the Autumn Uprising. And what a first appearance is, again, for the non-lawyers, is you come there, you decide you're going to enter a guilty or not guilty plea, and then your trial will be set down for another date. But what I saw, and honestly, when I first saw it, I thought it was a joke, was that if, in my own case, my solicitors had worked really hard because there was so much confusion because so many cases were being listed. There was so much confusion as to which date it was that my defendants had to attend. And my solicitors worked so hard to kind of get clarification from the courts, which you can ring a million times and you rarely ever get anybody to answer. And they got confirmation, okay, this is the date. So I went in, have the instructions, what I'm going to do. And I see the court pulling up other cases where somebody hasn't attended. Now, I already know myself how much we had to go through as people who are represented to find out what date this was going to be. And instead, people who hadn't shown up, the court was just deciding they were dealing with it kind of like they deal with road traffic cases, where they just proceed right then and there. Even though this is the first appearance, it's not your trial date. They proceed then to trial in absence. So there it is. It's just the district judge, prosecutor, no lawyer, no defendant, nothing. and it'll just go ahead, even though they know, even though we've all raised, there's an issue. I didn't know I was supposed to be here today. This person didn't know that. All that kind of real difficulties about listing, and still that was the process. And what would have to happen is that anybody who found out that they had been convicted in their absence would then have to do what's called a statutory declaration and say that they didn't know. But if you really think about this, this is a criminal conviction in your absence for protesting against real, like, the destruction of the planet. And again, like I said, most of the people who get involved aren't people that have long, lengthy previous convictions. So it's actually incredibly worrying that somebody might rock up to a job interview one day, get a DBS check, and find out, oh, okay, this is what's happened. So I think, again, in my view, it's another one of those kinds of things, trying to get through everything quickly by just convicting everybody, as opposed to taking a step back and thinking, well, do we need to actually be having these trials in the first place? Yeah, so that's kind of some of the things I wanted to mention in terms of some of the crazy stuff I've seen in the magistrates' courts. And then just in terms of kind of what was coming out of the April cases, we could see, well, there's clear case law, and Mike already mentioned it, cases like Tabernacle, that the place in which you protest, that location is as equally important as what you're protesting about. And so that place has to be taken into consideration when a state is going to interfere with that. And what we saw from the April protest was very much, okay, everybody's protesting in these locations. Well, reduce it to this location, move them further and further and further away until you kind of ended up in a park in Marble Arch, very different from the Waterloo Bridge or Parliament or where you had started that protest. So it doesn't surprise me that then come October, in the autumn uprising, in the case of Jenny Jones, of course, you saw what they tried to do was double down, a good old blackjack phrase, and just decide to ban the protests altogether under a Section 14 notice. And I'm going to talk to you a little bit about that case very briefly, because I think it's been touched on, but just for those who didn't know, what ended up happening was, knowing that there was going to be the autumn uprising, the Metropolitan Police decided to issue a Section 14 notice that was just widespread. So the idea is it wasn't tied to a geographical or temporal location or time. And what the court said in the Jenny Jones case was that that was unlawful, and that when they talk about a scene, it cannot just simply be every protest that falls under a certain umbrella. It needs to be specific to that location, because that's the way that Section 14 has been dealt with. But I think why I wanted to mention that is what I feel like and what it looks like is that kind of over time, over that year, it was more and more moving towards just trying to get rid of this nuisance, as what it seems like they saw it altogether, by just trying to ban protests altogether. So that was my kind of third point, just about what happened in October. The next thing is how it's going forward. And what we know now is, and Steph kind of mentioned this, because you're talking about injunctions and injunctions kind of being forward looking, and even before you've done anything. Well, what we're also seeing now, a trend in the criminal courts, is protesters being charged under conspiracy charges. And the thing about a conspiracy is it's the criminal offense, the agreement itself, and nothing has to actually be done in pursuit of that agreement yet. And I think that also speaks to where the criminal courts, and well, not the criminal courts, but where the criminalization of protesting is really going, because again, it's impending. It's offenses that haven't actually happened yet. So that is, I think, something for us to be looking out for, and just keeping on our radar when we're fighting back against the way in which there's a clampdown on protests. And then finally, what we know, of course, what Preeti Patel has said about, how did she the so-called eco-crusaders turned criminals, is how she referenced Extinction Rebellion protesters at the Police Superintendents Association conference. I mean, let's not pretend it's better than how she called the BLM protesters, which was like hooligans and thugs. But still, the background and how she views the protesters are clear. And the clampdown is clear because what she asked them to come out with, well, what she suggested was ways in which for police to effectively manage protests. And I'm actually really grateful to Netpol, who's done a lot of work on raising awareness about this. But it's the idea, it hasn't come into the houses yet, it's just been floated, the idea of a protection of the police and public bill planned for this year. And some of the things that have come out of that is one, and this should be no surprise to anybody who's been listening to this.
Audrey, you're going to have to summarize it quite quickly because we need to hear from Swan as well. So
2 seconds, I'm almost done. I'm at my last point. One thing is just this point, and again, like I said, no surprise to anybody. One of the things they're looking at is broadening Section 14 powers. So again, this power to kind of curtail where people can have protests. Again, trying to, in addition to this, what they're trying to do about Section 14, another suggestion is slightly watering down what it would require the police to show in order to impose Section 14. So things like, instead of serious disruption, significant disruption. And then obviously the favorite for the police, to increase stop and search. And again, it's something that we should be looking out for. We'll hear more about it this year. But just to kind of finish off, Mike put the quote up from Lord Hoffman and Margaret Jones. But I think it's kind of really important to kind of remind ourselves about, even though that was talking about, it's a quid pro quo, you plead guilty. The idea there was really the fact that protesting has a long and honorable history. Suffragettes and, people do that. People protest to make a difference and to make change, and they're vindicated by history. And like I said, we already know that people are dying because of climate change. It's not something we need history to show. And it should be, as Lord Hoffman said, a mark of a civilized community that can accommodate protests and demonstrations. But I am worried that the trend that we're seeing is the opposite of that. Thank you.
Well, thanks very much then, Audrey. And now we're going to move to Swan, who of course is somebody who is in the long tradition of protest, putting her body on the line and in the way in order to stick up for a number of important causes, including fighting climate change and so on. So Swan, over to you now, please.
Awesome. Thanks so much, guys, for inviting me. This is a very unusual setting for me. I don't think I've been surrounded by so many intelligent lawyers before. My background is in fashion design, so completely different to this world. And then I left all of that. I quit it and retrained and re-educated myself in the climate and ecological emergency. Because it's my moral duty to do so, and it's all of us, right? We all need to address it. It's the most important thing of our time, and it's affecting all of us around the world. And so I've started, at the time I found out about Extinction Rebellion, I was also planting trees and doing permaculture and working in Kenya, planting trees and various different things like that. And I saw this movement come out of nowhere, and I knew where I needed to be and what I needed to do. It seemed very obvious. And I've been doing that ever since. And that's because it's my human right, and it's all of our human rights. And when you look at the sort of research and history, we have an obligation and we have no choice but to act. And so, now I'm sort of doing two things. I'm doing Extinction Rebellion, sort of working with the global community as an international link for actions, both here in the UK, but solidarity around the world. So I'm in constant conversation with with people from around the world that are rebelling. And I'm just talking about this very briefly because it hasn't been, we've focused on the UK really, and it's really easy to fall into that bubble. But, you know, places like India right now with the farmers, and places like France, when they're sort of protesting in the same way we are getting completely different changes in laws as well, and mass brutality by the state. That comes back to, like, with the media as well. So they're blocking protesters from filming and documenting what the police are doing to them when they're protesting. And this is an essential tool that we use for our defence, to document what's happening to us. So this is happening in all places around the world, and not just here. So I just wanted to say that. So later on, in April last year, I saw my friend up at Crackley Lodge. You might have heard of him. Currently down a tunnel at Euston, protesting for HS2 Rebellion within the Stop HS2 campaign. And he's trying to protect those trees there, and we're all doing our bits. Now, when I came across HS2 Rebellion was when I saw him on a live stream protecting trees up at Crackley, being starved for 8 days by the National Eviction Team and HS2 security staff from drinking water or anything like that up a tree with a group of other people. And I was outraged by this. So I had to battle with the dilemma of going into lockdown or my moral duty to protect the environment, which was clearly going into this ecocide dilemma with the government fast-tracking this mega project in this country and using the COVID as a sort of blind shield from reality of what they were doing with this project. So I went down there and saw what was going on. On my second day on the camp, I witnessed wildlife crimes being committed by HS2, and we had evidence, and we contacted the police straight away. They didn't come until much later. It was shortly after that they fenced us in with fencing, HS2 staff. So then we became on their land. So they built the wall around us, so we became on their land, which was interesting. And then they started to sort of aggressively rugby tackle people down for being on their land, who were trying to document this wildlife crime being committed. That was very eye-opening to me, and the start of my journey on HS2 Rebellion and understanding of what was actually happening. And I'd never witnessed anything like this before. So within XR, I'd been, to protests in London, surrounded by concrete, and it very much been on our terms to a certain degree. But this was a sort of completely different ball game, and it was quite physical and emotionally draining, but also very eye-opening because I'd never seen anything like this before in my life. Later on, we had various different illegal evictions of different campsites. So we have them all up and down the line of the train being developed. And these camps sort of kept popping up. The more people heard about what was happening, came to protect the woodlands and the species on them and the communities. So a lot of people have been displaced by this project. They've lost their jobs. Like 19,000 people have lost their jobs, been displaced by this project. But what we hear from the government is they've created 20,000. So, this is the sort of things that we're dealing with. And within this sort of time period, which has gone snowballs from what it was back in April to now for me on the campaign, has been a crazy time. So I have been witness to or been closely related to people getting broken hands, collarbones, broken ribs, all sorts of physical breakages due to the National Eviction Team and HS2 security, and also the police, which is the really shocking thing for me. Not in all cases, obviously, and everyone's different, and there are some lovely people, but this is a very common thing to happen all too frequently. And I've also seen racial targeting on the campaign, specifically people chosen out by the police when we're doing non-violent peaceful protests, which is what we do. And yeah, targeted basically, and arrested and so on. And what else have I seen? Well, the use of power within sort of COVID and that dynamics, it's become progressively worse. And the last 2 weeks, we've seen more so than ever a very heavy-handed approach from the police towards peaceful protesters, documenting what's going on. And so, as I've described before, because of this sort of violent approach towards non-violent civil disobedience that we've seen on the protest sites, we have to document everything. It's so vital that we video what's going on so that we can use it later as evidence. That's essentially what I've been doing over the last 2 weeks of my life. And I've been blocked by it. I've been fined. I've been nearly arrested 1,000 times. And so have all my friends. Even my friend Paul here has as well, right? And, you know, it's crazy how things have escalated. I'm going to show you a quick video of an incident that happened in the summer last year to myself, where I personally received sort of brutality from the state, if you will, within the scenario of me being on an action and flexing my right to peacefully protest. There was a tree that was going to be felled. It was very ancient, and we knew that bats were living in it and other species. It was an alder tree, and it wasn't in their land. It was meant to be kept according to the maps and everything. But we saw them planning to cut it down, and we wanted to protect it for obvious reasons. And this is what we did. Just share my screen with you.
So we are here at Denham Protection Camp. We have been defending this walkway here, over the river Colne, and in particular the alder tree at the end there. For the last 2 days we've been on the walkways pretty much constantly, and yesterday our friend, amazing protector, was dropped from right where I'm standing right now. He was dropped as they dangerously and recklessly dropped the line, and he fell to the floor there and ended up took in an ambulance to hospital. But we were concerned today that they might take more risks with their lives. And the main risks that they've taken is, as you can see, hacking that ancient alder up whilst disturbing our lines. These lines were much more taut, much safer this morning. As the days progressed, they've cut and wobbled our lines, and it's been really quite intimidating, scary, and dangerous. How do you feel right now?
How do I feel right now?
Yeah.
Yeah, just like really tired, and my arms are aching. Just really achy and tired. I'm mentally drained, like really mentally drained. But it's fine. I'm doing what we have to do. Got no choice.
So they're gonna come in for you now, or what's gonna happen?
Yeah, that's the plan. They're going to shimmy on down and remove us from here somehow, probably in a harness and with the cherry picker, I'm guessing, but we'll see. Anyway, I really have to, I don't like balancing on my phone. Like, it makes me quite anxious, so I want to put my phone away now. Because they're going to like start moving around on the ropes and then I might get pushed around and stuff. It's quite wobbly up here.
Okay, good luck.
So, I'll see you later. See you on the other side. Bye.
Power to the people. People got the power. People got the power. Tell me, can you hear it? Tell me, can you hear it? It's stronger by the hour. It's stronger by the hour. Power, power. People, people, people. Running the line. We got all people moving. Chainsawing while they're threading someone's life. The man first safety line. Someone help her! Help her!
I'll stop it there because I know time's sensitive. So yeah, that was a bit life-changing for me. So that was the moment where I was cut down. They chopped the line that was attached. They had ropes all day, and they had someone. They had the Met Climb Team police in a harness, and he came across, and so they were trying to get me down safely with harnesses and all of that, but they couldn't figure it out for whatever reason, and so instead they resorted in just cutting the line. And it was really, really unsafe. And the paramedics that witnessed it and spoke to myself, and also later the previous day, who also was victim to this situation, said that they've seen, you know, permanent major life-changing injuries due to that height of a 25-foot drop. So it was like really scary, and yeah, that's the sort of thing that we're sort of putting up with, really, as protesters. And so people say to me, but you put yourself there, right? And as I said before, it's my human right to peacefully protest. And actually, I was given some options to come down. One of those options, they said, what would you, you know, how can we make you come down? And I said, I tell you what about if you give all of our belongings back? So during an eviction, they confiscated 30 people, including mine's life belongings, and didn't give any of them back. And then that morning, they sent us an email saying they were going to burn them all. And so this is the kind of people that we're dealing with on a daily occurrence. And all of the people that are connected are facilitating that. And that's really hard to hear for some people, but that's the reality. Yeah, it's challenging, but at the same time, as I said, we don't really have a choice because we're in a climate and ecological emergency. And so I guess my question is, like, to everyone, how can you help? Please help us. We need everyone to really do what they can. And there's 1,000,001 ways that you can help. But we really need to make ecocide law as soon as possible. And we really need to pass the CEE bill in the House of Parliament. And there's so many things that we need to do, but it's going to take all of us to do it. So that's an open invite. Like, if you want to help Extinction Rebellion or XR or any activists on the front line, people down the tunnel, whatever it is, that we're all in this together, and just, yeah, that's my plea, please. That's the end.
Well, thanks ever so much, Swan. And that is, we are all in it together, and it's very important that all of us who have concerned ourselves in taking part in this conference all support and help each other in the different ways in which we can, whether it's as a protester, whether it's as an academic, or whether it's as somebody in the legal profession or support or outside it that wants to provide and is able to provide legal and practical support. There are a few questions that some of them we've tried to address in writing on the Q&A and so on. I think what we're going to do, and Amy's confirmed that we can do this, is we're going to put all the chat and the Q&A on YouTube. This is good. This conference, this seminar is going to be put on YouTube as a separate link when we finish, and we'll try and sort of allow the conversation to continue on there, because we're coming up to 7 o'clock now. Everyone's overrun because everyone had such important and interesting things to say, and at the end of this meeting, I hope that people don't feel, although we've got at one level a sort of, people have been highlighting things that are problematic or difficult. The story is that this is an ever optimistic, ever evolving landscape. There's always some problems faced by different protest movements up and down the country and up and down the world, but ultimately many protest movements succeed. And the reason that we live in a very different society today from that which we did 100 years ago or even 50 years ago is because people have bravely put themselves on the line, whether in protest movements or in support of protest movements, and have been able to effect real social change. So we shouldn't be, although we're sitting there finding things that are worries and working out tactics to confront those, ultimately the message should be a hopeful and optimistic one, that protest movements work and that there's lots that we can all do to support and help those. So I think I'm going to wrap it up there, since we're half an hour over the time we're going to be. And as I say, the comments and the Q&A and stuff are going to be put on YouTube. So I'm going to just finish there by thanking all the speakers, all of whom have had stimulating and interesting things to say. And thank you to everyone who's been following it and taking part, all of whom have been asking interesting and worthwhile questions. I hope that deals with what we can say, and yeah, I think that's that's probably where we're going to have to draw the line. So thanks to all the speakers, especially those from outside Garden Court Chambers like Mike Schwartz and Swan, and thanks to everybody for all the work they've done, because it's been a very worthwhile evening. I'm sure you'll all agree. So thanks very much then. And we wave goodbye there like celebrity squares. that dates us all, doesn't it? Right. Right. So Amy is in charge of ending this in some way. So I think that's you can either leave the thing or it'll be brought to an end in a moment. But as I say, the Q&A and the chat are going to be downloaded for posterity. Thanks very much, you all.